My name is Annette Magnusson, and I'm the Secretary General of the SCC. And I'm very pleased to see, as Mike, so many familiar names on the list of participants. It's sort of a unique situation in the sense that we can actually follow in real time who all is joining us for the meeting. And I can see now, Mike, you're getting recommendations for what printer to buy actually in the chat function, so you can check that out. So anyway, again, a warm welcome to all of you, and we are really happy that so many people chose to join us this afternoon for this webinar. And my job here today is very simple. It's to say welcome to everyone and to, after that, join you as a member of the audience and listen to the panel and the panel discussion. And before we do that, a few words perhaps on the choice of our topic. I should say that the topic was really born from first-hand experience in SCC cases, where this discussion came up on how to organize online hearings when the parties cannot seem to agree on the way forward in this very unique situation we all find ourselves in. And we started talking, and we thought this would be a very good topic to have a conversation, really bringing strong experience to have different views on this and different ways of looking at it. And I think one of the many consequences from our perspectives and from many organizations of the COVID-19 outbreak is that many organizations and individuals have been forced into what I think could be called a fast track digitalization. This means that the adaptation and change that under normal circumstances would be allowed to take weeks or maybe even months, now needs to happen overnight and very fast. So this is a quite challenging scenario for many individuals and organizations. And to navigate, I suppose you would say, in this new scenario will require first and foremost a dialogue with everyone involved. If you're talking about an arbitration, to really have a constructive dialogue, but also in an organization and with your partners. It also gives, I think, an opportunity to reinvent the way things are done, to perhaps look at things differently and not automatically just transfer what is done in a physical setting or IRL and transfer all of that into an online setting, but really reinvent certain elements of the practice. It is an opportunity to do this. And it also gives an opportunity to take stock of what is out there in terms of different digital tools. Many of these things that we are now all getting used to working with on a daily basis have been around for some time, but we have not just been forced to use it, and now we are. And what is out there and how do we make the best use of it, given what we need and given the experience that we all bring into, for example, the arbitration practice. That is also one of the elements going forward. But of course, all of this also needs to happen within an acceptable legal context. So I'm pretty sure all of our panelists will touch upon all of these issues from their different perspectives. And we're very happy to have them on board. It's a very experienced panel, and you will learn more about who they are from our moderator, Patricia, whom you have already heard from, some of you at the beginning here today. And as Patricia mentioned, a few housekeeping rules as we move forward with this webinar. You will all be on mute by our tech people in the background, by our support people in the background. And this is just because we are so many people. So whenever you're making your coffee or your tea or someone is doing something in the background, wherever you are, it will not disturb the webinar. And I should say that the interest for this webinar has been record high of all the online webinars that we have organized this spring as a result of the COVID-19 outbreak. This is the one that by far has attracted the most interest. So we're very excited about that. When you ask your questions, as was mentioned, use the chat function in Teams. And Lise Alm and Fabian Unghause, two of our team members at the SCC, will help to pick up the questions and forward them to our moderator as we go along. I should also say that this webinar is being recorded. So in whichever way that may influence how you sort of post your questions or interact, you should be aware that this is being recorded. And we will make the webinar and the recording available later, perhaps next week or something like that. We just need to probably edit a little bit in terms of formatting. But other than that, it will be straightforward recording from the webinar itself. So with this, I am very happy to hand over to our moderator, Patricia Shaughnessy. And I think Patricia hardly needs any introduction in the world of international arbitration. She is the Associate Professor of Law at Stockholm University, and most importantly, perhaps, she is the founder of the International Commercial Arbitration Law Master's Program, a very successful master's program in international arbitration. She has also been a member of the SCC board from the early 2000s to 2018, including 6 years as vice chair of the SCC board. And the list of Patricia's achievements could be made very long, but I am very happy also to mention one, which is one of the particular favorites of all of her achievements. And it is that she is the winner of something called Boosting the Capital Award here in Stockholm in 2018, which is an award given out to an individual or an organization that has made substantial contributions to doing exactly that, boosting the capital. And Patricia was awarded this award as a thank you and appreciation of her work with the International Commercial Arbitration Law Master's Program at Stockholm University. So with this, I'm very pleased to hand over the air, I suppose, to you, Patricia. And again, a warm welcome to everyone.
You may be on mute, Patricia. Are you on mute by any chance?
We may have lost Patricia. She's not one who's ever at a loss for words. Hey, while we're waiting for her to rejoin, I'll take up just a second here as a party to arbitration to thank you, Annette, and the SCC, not for this, but I think people can express their own gratitude to you, but on behalf of a council and a party in arbitrations for all the SCC did in the initial stages of the pandemic. With respect to safety and promoting safety in arbitrations that were going forward. I think there was a little bit of inertia in the international arbitration community in the initial stages. You guys were right out in front. And as somebody who's been a lawyer in an oil and gas company for over 20 years, where safety is really, you can say nothing's more important, but in our industry, it's, safety, if you're not thinking about it every day, people die. And people die anyway, even when you are thinking about safety, unfortunately. I'm really grateful to what the SCC did, your leadership, to you personally, and to the SCC. So just thought I'd throw that out there. So thank you.
And I'm back. So I would like to pretend that I did that on purpose so that you would all experience what are the potential disruptions that can happen in the virtual world. And of course, one tries to avoid disruptions, but the real key in this virtual space is being able to adapt and stay calm and carry on, and have strategies for continuing to go forward. Anyway, with that, thank you very much, Annette, for the kind introduction, and apologies to everyone for the bit of the disruption. I'm very pleased that we're having this seminar today, and I'm really excited that the SCC has managed to put together such a great panel to bring diverse experience. So we're going to have, I guess you've met Michael Mcilwrath, who is Senior Counsel at GE Oil and Gas. There's a lot of experience in litigation and arbitration.
We're now Baker Hughes.
Baker Hughes, that's right. You're now at division. That was only a few years ago. And we also have Professor Dr. Maxi Scherer, who's also counsel at Wilmer Hale. And as you may know, she's a professor in the Queen Mary program. And Maxi, are you there?
I am. Welcome to everyone. Hello.
Good. And we have Wendy Miles, who is a partner at Debevoise in Plimpton, and I'm sure everyone is very familiar with Wendy. She is a very experienced practitioner, and she's also really a thought leader who's very involved in a lot of the current debates going on. And then we have live from San Francisco, I guess the sun hasn't come up there yet, but Paul Cohen has come up, and he spends his time between San Francisco and Gray's Inn in London. And Paul is well known for his expertise in arbitration, and in particular in technical matters. And so, Paul, are you still with us?
I am. Hello. Good afternoon. Good morning from my perspective.
And Wendy, are you also with us now? Do we have Wendy on board?
I believe I saw her in the list. Might you be on mute, Wendy?
Yes, I am here. I'm just, hello.
Great. Hello, Wendy. Good to see you. So, live from New York, San Francisco, Florence, and Stockholm. We will now get kicked off. And let me indicate that the plan that we have is that we will address the issues that were in the flyer, but maybe not exactly as the way they were listed. And we will start with Maxi providing us with a legal context and providing us with the background for the issues that we're addressing, in particular, when we have a party who is not willing to agree to the virtual hearing, or at least not agree to some of the logistics and procedures which are being suggested. And she will walk us through the context. And after she makes a presentation of about 7 or 8 to 9 minutes, we'll have a bit of a discussion with the panelists. And then we'll move to Wendy, who will discuss how a tribunal or the parties can deal with and engage the parties in trying to get everyone on board and embracing and successfully having virtual hearings and using the tools that are available. We'll then have Mike join us, and he was going to suggest to us that we should not simply try to replicate hearings as we know them now in the virtual space, but that we should try to find new ways to be effective and to achieve the outcomes that parties want. And then Paul is going to come in, and he is going to walk us through the toolbox, which seems to be bulging and new additions every day. And how do we sort through and select? How can we use these to effectively achieve it? And as mentioned, each person will make a presentation, and followed by that a little discussion within the panel. And then we will save 15 minutes at the end to have the panel address your questions. So please do use the chat function to bring questions in. I'm very happy to have Lise the head of business development at the SCC, co-piloting. She's actually doing more of the piloting, perhaps, because she's going to catch the questions and send them over to me, take care of all the technical things together with Fabian. So with that, I turn the floor over to Maxi.
Thanks a lot, Patricia, and hello, everyone. Good morning, good afternoon, good evening, wherever you are. I'm delighted to see so many of you here joining the seminar, so many familiar names. That's really great. So I have the pleasure of addressing the legal aspects of holding a hearing against the wish of one parties. I think we're going to see some slides in just a second. I'm going to be trying to be very quick on those points given the short time we have. But maybe just to set the scene, I think it is important, as Annette has reminded us in her introductory words, that online hearings and remote hearings are nothing new. The technology has been out there. We've been using this actually for a number of years. I certainly have participated over the past 10, 15 years in a number of hearings that had a remote part or were conducted remotely. You might have seen that ICSID has just for a couple of days ago released a statement in which they indicated that last year, 2019, a majority of their hearings, about 60%, have actually been conducted using video conference. So just as a reminder to all of us, this is nothing new. What is new, however, in the current context of this pandemic is that we are potentially forced to do hearings where every single participant is participating from a different location, so that you don't have one or several main venues and some remote venues, but actually only remote, single venues and participants potentially from all around the world. And that raises additional difficulties, technical difficulties, and others that I'm sure we're going to address on. In my remarks, though, in terms of the legal framework, I will address all of those remote hearings, whether they are semi-remote hearings or fully remote hearings, unless I specifically say one or the other. So maybe starting with the legal framework, and this is on the first slide, it is, as a starting point, if we can go to the next slide, as a starting point, there are no national laws or arbitral institutions that impose or prohibit the use of online hearings. So that's the starting point. There are a couple of national laws or arbitral institutional rules that do refer to the possibility of conducting online hearings, but they do so in permissive terms. You have here the LCIA rules as an example on the slide, clearly indicating that the arbitral tribunal may do a hearing in form of a video conference or telephone conference, or in person, or a combination thereof. So there is clearly a permissive language and a power given to the arbitral tribunal. There are other national laws, there are other institutional rules that do so, but they are in a minority. Most of national laws and most of institutional rules actually do not address the issue up front. And then the question is, what happens if one of the party is reluctant to move ahead with a remote hearing? And this is on the next slide, some other principles that will guide us in making a determination whether or not it is possible to move forward with a virtual hearing. One of them is that a party is typically granted a right to a hearing in a number of provisions from national laws or institutional rules around the world. You will all be familiar with, if you are joining in from Sweden, Swedish Arbitration Act, and the provision of the SCC rules, which is here on the slide, that a party may request a hearing. And I am aware that in Sweden, but also in other jurisdictions, some authors have expressed a view that a hearing means an in-person hearing. Now, I'm not going to say anything about these specific jurisdictions, and I'm certainly not going to tell a partly Swedish audience what is happening in Sweden. But from a general point of view, taking a step back, I'm somewhat puzzled by that statement, because a hearing is, if you think about it, something where potentially orally arguments are exchanged in a simultaneous or live manner. And that, of course, can be done remotely as it can be done in person. We are currently using oral verbal language. You can hear me, you can even see me. And we are exchanging arguments in a simultaneous fashion. In the same way, in a virtual hearing, in a remote hearing, you do oral arguments, oral evidence, just by using modern technology. An interesting illustration of that same problem can also be found in the ICC rules. I'm sure you're all familiar with that intricate problem by now, that Article 25 of the ICC rules refers to the fact that an arbitral tribunal shall hear the parties together in person. And it is that particular in-person language that has given a headache to some thinking about remote hearings under the ICC rules. However, if you look at the other linguistic versions of the ICC rules, the Spanish version, the French version, for instance, they do not contain that same in-person language that you have in the English version. What they do say, my French is better than my English, is that you're supposed to hear the parties de manière contradictoire, in an adversarial fashion, so that the parties can exchange arguments simultaneously. And again, that I would submit is possible even in a remote hearing, and that has also been noted in the recent ICC guidance note that has been put out. But where does this leave us with a party opposing to an oral hearing? So on the next slide is what I think the basic and important principle. We can turn to the next slide, which is found in most national laws and in most arbitral institutional rules, which is the broad power of the arbitral tribunal to conduct the proceedings as they consider appropriate. And that, of course, includes to determine when, how, where, etc., a hearing is to be held. And that, in my view, also includes whether or not a hearing can be held remotely. That power, as broad as it is, however, is not a sorte de carte blanche given to the arbitral tribunal just to go and do whatever it pleases. That power really is restricted and should be carefully exercised. And the arbitral tribunal should and must carefully assess all the circumstances of the case to determine whether in that particular situation an online hearing, a virtual hearing, is warranted. And that is a delicate balancing exercise. And basically the two principles that need to be balanced is, on the one hand, the duty the arbitral tribunal has to conduct the arbitration as expeditiously and efficiently as possible, and on the other hand, the party's right to equal treatment and the party's right to be heard. In the current context, the duty to conduct the proceedings efficiently and expeditiously is particularly problematic because we don't know how long this pandemic is going to last, and therefore if we postpone a hearing, we don't know how long that postponement is actually going to last. On the other hand, the party's right to equal treatment and the party's right to be heard, a couple of brief remarks here as well. When it comes to equal treatment, if you consider a fully remote hearing where everyone participates remotely, the parties, all the experts, all the witnesses, all the tribunal members, arguably there isn't a problem with the right of equal treatment because precisely everyone is participating in the same way. So the question here is more for the semi-remote hearings where, maybe one party or some experts or some witnesses are heard remotely, but not others. I have looked at case law around the world. I have not found any particular case where an arbitral tribunal's award was set aside or refused recognition and enforcement on the mere fact of such a treatment. If you are aware of one, please do send it to me. But that, in and of itself, of hearing one party's expert or witnesses remotely, in and of itself, did not seem to be problematic. On the right to be heard, again, the question here, and I'm sure we'll debate it in more detail with the other speakers, is to what extent, for instance, you can do effective cross-examination of witnesses remotely, and to what extent that then impinges on the right to be heard. Again, I'm not aware of any particular case where the mere fact of conducting a hearing remotely has raised issues at a set-aside or enforcement stage. Of course, there might be additional problems. There is case law where courts have considered what happens if technical issues arise so that you cannot properly hear the witness or you cannot properly cross-examine the witness. But the mere fact of conducting the hearing is not problematic in and of itself. Now, I'm mindful of my time, but I have one more slide I would like to get to, the next one, which is in that delicate balancing exercise. I think there are a number of factors to consider. I've put here a couple on the slide. They're by no means exhaustive, but I think some of them are important. I'll go through them quickly. The first two are what are actually the reasons for the remote hearing? Why is there an absence? And what measures have been taken to ensure presence at a hearing in person? Now, in the current situation of our pandemic, the answer to that is obvious. But after, when we go back to our normal situation, these are really important questions to ask. What is the reason for a certain absence of a witness or an expert or parties in particular, and what measures have been taken to compel or ensure presence? Another question is, what is actually the hearing about? Is it about legal arguments on a procedural issue, or is it about taking of evidence? Again, coming back to that potential argument that taking of evidence is more problematic and raises more technical and questions in a remote hearing. And then how critical is that particular witness or expert's evidence? And finally, is it actually possible for all participants to connect remotely? We take it for granted that that is the case. A very recent Australian decision in the context of national court proceedings has said we should not take it for granted. Whether that is true in international arbitration as well remains to be seen, but there are certainly jurisdictions where one could question whether a stable internet connection can be taken for granted. And that the $100 million question, as I said, what is the delay if we don't do an online hearing? And in the present circumstances, this is really the open question in terms of how long this pandemic will last. So these are just some considerations in terms of the legal framework when it comes to online hearings. I'm sure we'll be able to discuss some more practicalities and more interesting parts on how to conduct them after we've heard from the other panelists. But I'll stop here and hand back over to Patricia.
Thank you very much, Maxi, for that excellent overview and giving us a good platform in order to examine these issues and discuss them more. We have about 3 minutes before we turn over to Wendy. I'm going to be a very strict timekeeper, so everyone will get their 15 minutes of webinar fame. But I would just like to bring up a question that Bernard Hanno-Chow has posted in the chat, and that is, what is the problem with hearing in person? Isn't the hearing on a platform such as we're using now, isn't that in person? Everyone is appearing live in person. And I think it's an excellent point. And in fact, I think that that's probably what 99% of the Swedish arbitration community thinks the Swedish Arbitration Act and SCC rules would accommodate. I'm aware of a outlying commentator, but would you like to respond to that?
Sure. I mean, Bernard that's indeed a very good question. And I can only say from my experience when conducting hearings that were done at least partially remotely, the evidence taking, provided the technology works, you really do have the impression, even more so maybe than in a live hearing room, that you have someone in front of you. And the concerns that some people have that you cannot assess the credibility of a witness, I think for everyone who has done this can actually say, if you see someone on a big screen in front of you, you will see every twist of their eye, every twinkle in their eye, and therefore you have an even more immediate impression of someone, as opposed to if someone is sitting 5 meters away from you in a hearing room that maybe not you can't see very well because the lighting isn't great, etc. So I really do think, from my personal experience, that that in-person feel is there even in a remote hearing. Now, I can say that this is not only a personal experience. There has been a really interesting survey in 2006 in the US in national courts, where court judges that use video conferencing have been asked to share their experience. And one thing that comes out of, a couple actually interesting things come out of this survey, that is, overall, they do think that the benefits outweigh the disadvantages. They also think that they ask the same amount of questions, they interact in the same manner, and particularly so the more experienced judges, and not experienced in terms of seniority, but experienced with video conferencing. So the more experience you have, the more comfortable you are with the medium, and that the more you think, yeah, it's actually just the same as sitting in a room together. And this is where the current pandemic has the potential of being a real paradigm shift. Arbitrators and national court judges in the current situation get more and more experience with virtual hearings. We all get experience through these seminars, and we do get used to it, and we do see that it works. So I think that has the potential of making us move, as Annette said in her introductory remarks. .
Patricia, you're on mute.
Yeah,
There you go.
sorry. We now have exceeded our 15 minutes for the first speaker by 1. And since I'm being rather picky here, may I invite one panelist to make a comment?
Can I just say, so I'm just going to jump in, this is Paul, I agree completely, 110% if that's possible, with Maxi and with Bernard also. I think the reason why there was hesitancy about video in arbitration was, of course, the possibility of a challenge or an annulment. And as we are going to find in this environment that the courts are going to become really, really familiar with video very, very quickly, I think that fear evaporates. And I think that's going to be the key.
Thank you. Wendy, I know you have a lot of experience.
Hey, before can I just jump in? Can I ask a question back into the comments? Because Bernard, you were an arbitrator in a case I had over 10 years ago, and we offered, this is historical so long ago. Maybe you could feed back in the comments. How would you handle today when we asked to have a video hearing instead of flying all the way out to Singapore for a 2-hour hearing? I know I'm saying that those are the things that 10, 15 years ago. How do you think you would handle that differently today? Maybe you can answer in the comments there. Sorry to interrupt here.
Okay, now back to Wendy. Wendy, and I imagine that Bernard's going to probably say that the technology in 10 or 15 years ago was a bit different than what it is today. But
I will
Wendy,
predict that Bernard will say he wasn't the chair, but that wasn't his decision. Okay.
Wendy, given your experience, I'm sure that you've encountered a number of co-arbitrators and parties who were a bit reluctant, and it's difficult to get them to embrace. How do you get everyone together to move forward in this type of an environment?
There is a very easy, thank you, Patricia. There's a very easy answer to that. You communicate. That's really the primary and principal answer. Communicate and communicate well. But thank you. Thank you to the SCC and Annette and Lise for this important seminar, because in the course of the global lockdown, there has been a plethora of arbitration-related panels, protocols, and practical guidance as we've responded to this new world that we've been thrust into, and indeed this new way of working. But this, as far as I can tell, is the first panel that has taken head on the seemingly vexed issue of what to do if one or more parties don't agree, or indeed an arbitral tribunal doesn't agree to proceed with a virtual hearing. Because as Maxi said, it's not a problem that can be overcome immediately or in any known or knowable way, because we don't know how long we'll be conducting business this way. And when it does lift, I think what we do know is that that will be slow and incremental. And if all hearings are pushed off until such time, there'll be an enormous backlog and backup, and the efficiency which we all laud about international arbitration will be eliminated overnight. And I think that's a really, really big practical concern. Maxi laid the legal groundwork. As a matter of law, it's clear, and it should be clear to everybody, that few, if any, national arbitration statutes, procedural laws, or institutional rules prevent or prohibit an arbitral tribunal from proceeding to resolve a dispute without a physical hearing of people in the same room. We already knew this, of course. As Maxi said, very few people on the call wouldn't have already participated in a hearing or heard of or had someone they know participate in a hearing where at least one fact witness or perhaps expert witness was cross-examined or examined, gave evidence through a video link, either because of visas, health, their own work commitments, or other travel limitations, well before COVID-19 and the current situation. And like Maxi, I am wholly unaware of any arbitral award that has been successfully challenged or not enforced for that reason. Yet the SCC finds itself today with a record number of people signed up to hear about precisely this issue. So why is that? Well, maybe you're all craving for human contact and company, but maybe it's because we just can't quite bring ourselves to believe that a party can be compelled, forced, made to conduct an international arbitration proceeding without having the physical in-person hearing. Or maybe we don't want to believe that because it challenges what we think we know about international arbitration. Perhaps it challenges what we think makes us the specialists and the experts, particularly as counsel in international arbitration. And perhaps it takes away or threatens to take away the thing about international arbitration that we enjoy the most, the physical hearings in the same room. So in response to your question, I'd first like to explore with you what we think might be holding parties back, or indeed holding arbitrators back from taking a new and different approach, and whether the concern that does hold them back, and it does, we've all experienced it, can be addressed, eliminated, or resolved, because we are, of course, in the business of resolving disputes. So Maxi kindly directed me to Richard Susskind's latest book, Online Courts, fortuitously timed in its publication. He's talking about, if one were into conspiracy theories, he's talking about online dispute resolution procedures as opposed to virtual hearing, but mostly he's talking about how we administer the law and resolve disputes. He says this: the disconcerting message here for all professionals is that clients do not really want them. They want the outcomes that professionals bring. And Mike's thumbs up. You can do that virtually as well, Mike. And when these outcomes can be reliably delivered in new ways that are demonstrably cheaper, better, quicker, or more convenient than the current offers, we can expect the market to switch to the alternatives. That's Susskind, and he argues that focusing on current ways of working rather than whether the outcomes that court lawyers, or in our case arbitration lawyers, deliver might be achieved in different ways is the wrong approach. So in these days, as we find ourselves all, frankly, for me, the first time ever, free from the madding crowd, we might take the opportunity to reflect on what services we, as arbitration practitioners, are hired for, and what is and is not essential to those services. And we should be honest with ourselves, and we should listen carefully to our clients. We should ask them. We should take the opportunity to speak with them about it, at least as much as we speak to our teams. They are the users of our services and the systems. We should ask them what they want from us. And according to Susskind, what we all want, users included, is a system of dispute resolution that's authoritative, respective, and supportive of the principles of justice. We want a system that's considered relevant and not detached, according to Susskind, not detached from mainstream social and working lives of stakeholders. That's important. This lockdown is moving society, it's moving business, and it's moving the way we work and live in every possible way. There will be a new and a different normal when this passes. And do we, lawyers and arbitrators, expect or want to be the only ones going back to the way we used to do things, unchanged and unaffected? And if we do we risk that our users decide they don't want or need that anymore? So Susskind argues that at the end of the day, dispute resolution systems need to provide substantive and procedural fairness. And it's interesting because the procedural issue, the concerns that have been raised to me, both as arbitrator and as counsel, in respect of virtual hearings, have all been procedural. None has been substantive. And when you think about it, we argue the substantive issue in the law mostly front-loaded in the papers anyway, and then the tribunal goes away and writes its award in a room on its own in paper form. So it's the procedural concerns that raise the objections. And as Maxi's explained, most of our arbitration laws and procedural rules are broad enough to overcome these concerns. But in a perfect world, what we would do and what we should try and do, because arbitration is, after all, a consensual process, is try to get all of the participants on board with those procedures that are most effective including now and beyond COVID-19, where appropriate, virtual hearings, or indeed, as I think Mike's going to come to, no hearings at all. So the procedural issues that are raised have been outlined. If you haven't already seen it, and a couple of people sent it to me before this session as well, so I thank you all for that. This decision that Maxi referred to in the Federal Court of Australia, it's the Capac and Ford Motor Company of Australia decision, and it's federal court. It's a very short judgment. It's been doing the rounds on OGMID, and there's 7 issues that the judge identifies as being the procedural objections to virtual hearings. The first is technological limitations, and as Maxi said, you know, that can be valid and needs to be overcome, but it shouldn't be assumed. And again, as Maxi said, particularly in the context of international arbitration, it shouldn't be assumed that there will be some form of technological inequality or inability. And the 200 plus people on this panel this morning would show the opposite. In fact, what technological limitations often are at the end of the day is technological fear or technological sort of lack of comfort. And the institutions and the hearing centres and a lot of service providers in our broader community are doing a fabulous job of providing guidance, tutorials and assistance to anybody who has a sense of discomfort with technology. Frankly, I think those on this call have overcome that. Second concern that the judge mentioned was physical separation of legal teams. Now, law, and this came up earlier in the week on another session I was listening to, law is probably one of the last bastions in legal business where we still have our own offices. We consciously and deliberately separate ourselves every single day. We email the person in the office next door or ring the person down the hall. Physical separation of legal teams, again, is a perceived obstacle. I don't think it's really real. And I think if we think about it and we're honest with ourselves, it's not such an obstacle as we make it out to be. Certainly during hearings, when somebody's making submissions and you're sat along in a physical room in a row, you're communicating with one another in all sorts of ways, often by passing notes. These days, those notes can be passed by WhatsApp just as much as on a yellow sticky. There's nothing to stop you doing that. In fact, it's sometimes much easier to do that without disrupting the flow of the proceeding if you have a separate computer in your own room. Expert witnesses and fact witnesses. Again, the judge in the Australian decision talks about what the concerns are, but Maxi summed them up beautifully, as she always does. If it's a feeling that you can't look at someone in the whites of their eyes, get a bigger screen. And then document management. And once again, in respect of document management, the SCC has been an admirable leader and offered its fabulous platform. And I say that having conducted an arbitration with the SCC as an arbitrator recently. The online document platform is ahead of anyone else, and it's incredibly simple and straightforward to use. It's not a complicated platform or interface or piece of technology, but it's an absolute godsend in a normal world, let alone in the world we find ourselves in now. So document management platforms are available. We use them anyway, and it's just making sure that we get over our addiction to A3 spiral-bound bundles. And then the judge also talks about future issues, so issues that just practical issues to overcome in the household, the dog coming in, the kids coming in, someone practicing guitar or drums in the background. And then finally, the trial length and expense. And I think we all know that this reduces trial length and expense. once you actually start to explore the issues, and if you're looking for answers as an arbitrator or a counsel in trying to answer any of those issues, this judgment is a really good place to start, because the judge just deals with them very succinctly and very neatly. And I think the points he makes are absolutely relevant to arbitration. So once we actually start to examine what the issues are and talk to the parties about those, then I think we find, and this has been my experience, that the parties do come together in consensus, and nobody, neither an arbitral tribunal member nor a party, needs to be compelled to do anything that they're not prepared to agree to do, once they understand that so many of those procedural concerns can be overcome, and actually the process in some ways, in many ways, can be enhanced. Beyond that, and looking beyond where we are now and COVID-19, it does beg the question again, and it's been begged a number of times, whether instead of the terms of reference in ICC proceedings, or procedural order number 1 in any arbitration proceedings, being trotted out in every single case, working backwards from the holy grail of the date for the in-person physical hearing, which needs to be worked around all the participants' busy schedules for the next 2 or so years, perhaps we should refocus or reset the starting point and communicate with one another from the outset of proceedings. The ICC added an annex to its rules some years ago now on case management, setting out a number of points that could and should be discussed at the beginning of hearings. It's been very, very difficult to move our community to do things differently, to adapt. Often it takes dramatic events, as Maxi said, necessity is the mother of all invention. So as we find ourselves here now, it's time, as I say, away from the madding crowd, to reflect on the service we provide, and whether beyond virtual hearings versus physical hearings, there are not ways that we can provide a better service, a more efficient service, and a service that is fit for purpose in the new normal.
Thank you very much, Wendy. I think you probably did a great job of getting, can you hear me? Not good. I think you did a great job of getting Mike warmed up. I think he's in the gate and ready to go. And because we're a few minutes behind schedule, and we don't want to have made Paul get up in the middle of the night and not give him his 15 minutes. So I'm going to go right to Mike. But before I do that, I want you to know that your question to Bernard has been answered. He wants you to know that just today, he's part of a tribunal where they agreed to a 3-week virtual hearing. So with that, I will turn the mic over to Mike. Mike gets the mic.
Well, thank you. And by the way, we can go to the first chart here. My title here is about innovating. Are we innovating or just replicating what, putting online what is already inefficient today? And I'm grateful to have Bernard here as kind of an additional silent panelist with us here to bounce off of. And I'm not surprised that Bernard has now had not number one, that he mentions having a 3-week hearing that over the objections of one of the parties that has gone forward, and 2, that he's aware of a software that an app allows you to scan the room. I think that's why people appoint Bernard, because he's an arbitrator who will take those sorts of decisions to move things forward. And I think that it's already been covered so far that both Maxi and Wendy have talked about. Really what we're talking here at the end of the day is justice and moving things forward. And I've had an ongoing conversation with Bernard over the years. I'm a common law lawyer by training. And for more than the past 20 years, I've been based in Italy, where I would say probably most of our disputes tend to have a civil law aspect to them. And I've always looked and found to the civil law, and Bernard knows this very well because every once in a while we have a conversation about this, about, there are tools in the civil law that seem to me to be advantageous or more advantageous than the tools that we get from the common law, to Wendy's point about helping the parties to reach a resolution. And I don't think it's a question of harmonizing approaches. I think sometimes it's a question of adopting a better approach that one system or the other offers. And so what I wanted to talk today about is either minimizing, and I want to be a thorn, I've labeled myself as a bit of a thorn in the side of these proposals for virtual hearings, not because I don't think that we shouldn't have them. And by the way, I'm both a claimant and a respondent in terms of the cases that I'm involved in, so I have to be careful. Anything I say will be used either way, in either direction. I think what I can come down on in favor and say in all of the cases, we would like to have an efficient, competent, and fair resolution. And if you look at this note that the ICC has put together on the mitigating the effects of COVID-19, as Wendy mentions that she set up there are a number of case management tools which have long been available. And what I'd like to talk about here is how almost none of these require any sort of online anything. They don't require a hearing, and yet they permit forward momentum in cases. And importantly, I think they also permit arbitrators to bill for their time, to be compensated. I think one of the things that we need to be mindful of, even as parties who pay, is that if everything is standing still, it's not just that restaurants aren't getting paid. I mean, arbitrators aren't going to be getting paid if they're just postponing things for 2 or 3 months. So I think we all have an interest in doing something to move proceedings forward. I've put here this little arrow at the bottom of the screen, which to me is just, have the dollar signs as the value signs, kind of like you go to a restaurant, right? You have the more expensive on one end and the cheaper on the other. But that to me really is, it's just an obvious, as you go on the dispute resolution process, how the costs escalate. And everything is focused on what I would call in arbitration this common law, and the tradition I was trained in. This, I would say, the theatrical aspect, the performance side. It's all geared up to getting to the hearing, and because the question I would raise as a party, as the one paying for this process, is: do we really need this hearing? Number one, at all. Do we need it all? And number two, if we are going to have a hearing, might we just try to minimize it? And I have a rule of thumb, and I think again, Bernard has this years ago confirmed this for me, that if you are holding a hearing in New York or London under English law with American, Australian, or English, actually the Australians are even longer in their time scales in terms of hearing lengths. Sorry, Australia, but I do find that your arbitrations tend to be even longer than even a New York hearing or a London hearing. But if you look at the length of time that is allocated to hearings, my rule of thumb is in London or New York, 2 weeks it would be a hearing that in Paris or Geneva would be 2 days. So I have a 5-to-1 multiplier. So, it's the same arbitration. It could be the same contract, same dispute. What's changed really there is the arbitrators and the party, and the counsel, and their orientation towards the case. So again, why would you have, Bernard, I guess the question back to you, why would you permit anybody, do you really look forward to sitting through 3 weeks of a hearing? And might there have been a way to reducing that perhaps to 3 days? Again, going back to this, can we collapse things? Can we simplify things? If we look at the ICC note, which was drafted by Wendy and others to really to help parties and tribunals confront and deal with and avoid just delaying things. Article 8 of this has, if we go to the next page, you'll see a number of tools here that I'll just go. I won't go through all of these, but I'll simply say that if you go to Article 8 of the ICC note, you'll find this long list of case management tools that Wendy mentioned. Most of them do not require, you can get things done in the case, you can have things decided. And I can tell you as a party, feeling that things are moving along and going forward, you will have, I think, also a higher level of satisfaction from parties. To take one example here, just right at the top, can you identify if things can be resolved without any hearing? You know, can you look at potentially the fourth item here, considering the resolution of potentially dispositive issues? You know, that party that maybe didn't sign the arbitration agreement. Well, maybe you could simplify things by just deciding up front. Maybe they shouldn't be in the arbitration. If we can go to the next page. Again, these are just a list of the items, the things that, again, don't require any type of a hearing. You know, identifying issues that may be resolved without witnesses or expert evidence by being innovative as arbitrators and submitting written questions or accepting questions from the opposite party. Those are things that all can be done by the exchange of documents. And if we go to the next page, so you see we already have 8 different case management tools. Here's some that are listed in the ICC note that might imply the need for video, not necessarily a hearing, but they might imply some need of video. One would be disposing expeditiously of unmeritorious claims or defenses. Again, going to Maxi's point about whether, you know, parties are entitled to a hearing, I guess I'm of the view that parties are entitled to a right to be heard. The right to be heard, to me, it doesn't always necessarily imply that it has to be a hearing taking place. I think many of these things can be decided on the basis of documents. I think that's something that has to be decided in every single situation. You know, using either audio conference or video conference where appropriate. Well, you might not need the video conference. You might be able to just do it by telephone. And then if we go to the last bullet point. Again, this is the same point there, using either audio conference or video. So maybe you might decide to use video. So again, the ICC has listed what I think are case management tools that have been available for quite some time. And what we need now as parties is tribunals to be, I think, a bit firmer in being willing to implement these over the objections, as Bernard says he has done in one case, but over the objections of one of the parties. Why? Well, because we want justice in the end, and we want to keep the forward momentum. We want to keep the progress going in the cases. And my prediction is, once these innovations, once these case management tools begin to be adopted, to Wendy's point, I don't think that we'll be going back. I think that these are things that parties will say, you know, I like the way that was handled. And we'll see it being adopted voluntarily in the future when we're on the other side of the pandemic. So those are my few points, Patricia.
Thank you, Mike.
If you'd like, just a second, I would like to respond. There are a couple of early questions that I think kind of touch on this that were submitted.
Maybe what we'll do, so we don't go into Paul's time, that we'll save him for the Q&A at the end. But just as we move to Paul, let me just ask you one quick question with a short answer. Someone has asked the question of, do you as someone who advocates negotiation and mediation, do you think in this virtual space that we remove the possibility for opposing counsel to meet during coffee breaks and start to perhaps identify issues that they can resolve, or maybe even resolve the whole case? Can we keep that opportunity for discussion and dialogue?
But by the way, I think that's look. There are a couple of questions that came earlier on. I think these are the things that people should be thinking of. Exactly. How do we keep the good and bring it forward with us? And how do we not? By the way, just there were 2 questions asked earlier. How can you have 1 or 2 arbitrators actually at the hearing room, a hybrid process? I'd say yes. Think of things like this. Or there was another question that said, shouldn't we have 3 cameras on the witness? It was a question from Dubai, which I guess, you know, if you had a really important witness, I mean, why would you do that with every witness? I'm just thinking as a party, I mean, my gosh, the digital aspects, storing all that information, the cost of doing that, and what you're doing is you're doing more than what we have today. I mean, at least in the hearings I sit in, you've got 3 arbitrators sitting back there, witness sitting in front of them, and now you would have witness. I mean, I guess we could do that, have cameras from all sides, but then you're really now invested into the witness being everything in the case, which I think is a wrong direction for arbitration.
Good. We're going to come back to all of this in the questions, but now we're going to have Paul take us on the quick journey about all the tools that are available and how do we sort through and select them and get the tools that actually fit for the case and the job.
All right. I hope you can hear me. I apologize. I was having technical difficulties with my Bluetooth, so I'm just on the computer speaker. So tools to adapt to the new world, and a little bit of context in light of what Mike and Wendy and Maxi have been saying. Video conferencing is not new. In fact, it dates back, shockingly enough, to 1964. Of course, it was not widely used till about 20 years ago, and not in the internet context till 15 to 17 years ago. But it is a mature technology, and I don't think we need to be scared of it in any way at this point. In the broader context, again, in light of what Mike and Wendy and Maxi have been saying, it's really not just the question of let's not make the perfect the enemy of the good, but really what exactly do we mean by perfect anyway? And the assumption seems to be, as we have averted in the common law context, that perfect means in-person hearing. A very prominent ogimeter, I guess ogimid is subject to the Chatham House rule, so I won't identify the ogimeter, but a very prominent ogimeter recently was canvassing a number of views on the procedures in light of COVID-19, and the ogimeter subsequently conveyed some anonymous comments. And I just want to read one of those comments because I think it's instructive. Again, I can't identify the commentator because this is anonymous anyway. So what it says is, I'm an early adopter and great technology enthusiast. Still, I am seeing a certain distraction and infatuation with video conferencing technology in cases where it just isn't necessary. How many of us do preliminary hearings by video conference in normal times? Yes, yet, for some reason, now we all think that is the new standard. Perhaps it will be, but I've seen on several sessions where talk about the technology has overwhelmed the substance. I would submit that's precisely backward, and with apologies to whoever that anonymous commentator is. I think that, as everyone has been saying, what we should be looking for in the first principles are the ways in which we can efficiently resolve disputes in this modern world, and not make a fetish out of in-person hearings. Notwithstanding some of the very valid comments about people meeting in coffees and coming to settlement and so on and so forth, I think that there are massively more important factors which will, I think, militate in favor of remote dispute resolution. So let's talk about some of these platforms, and there are, I think, a plethora of them, and it's a bit sort of mix and match, Coke and Pepsi, pick your poison, take whichever metaphor you want about these. There is, of course, Zoom. There's WebEx, which is a Cisco product. There is a thing called Blue Jeans. There is something called GoToMeeting. There's a new one called Starleaf. Facebook is even in on the act now with one it's going to develop called Rooms. You have seen in the arbitral context recently in the past month, many of these being used. Obviously now we're on MS Teams, Microsoft Teams, because Microsoft Teams, Lisa Alm tells me, is more easily integratable into sort of the whole document management system, and props to the SCC for coming up with an integrated system, being the first to do so. Otherwise, they're sort of all much of a muchness, and some of them have features that are useful to arbitration. I think some others of them probably need to work on it. For example, Zoom, as far as I know right now, does not have a chat room function. So you can't have the arbitrators pop into a chat, into a sort of a different little video and then come back and confer amongst themselves. What you have to do in the case of Zoom is put everyone else into the waiting room and then have your discussion and then bring them back out of the waiting room. WebEx and MS Teams, it depends what software you get. I've actually had this occur to me recently, where we've got the wrong type of WebEx system, for example. So there is apparently a WebEx system that has a chat room, but not the one we had. So we had to sort of go on and off of the WebEx platform to conduct discussions. So all of this really suggests that what you need in this context, at least at the beginning, is some kind of tech manager, sort of a tribunal secretary for tech, if you will. And again, the SCC is ahead of the game with respect to having an integrated platform, but you will need, I think, someone who is able to navigate in that particular, whatever platform you use, the various different technologies and the screen sharing functions. For example, screen sharing in most cases just consists of whoever the user is at that particular moment putting up whatever document they have. So if you have, for example, your private notes on a piece of paper, on a document, and you want to, obviously you don't want to show those publicly, but you want to highlight something for the sake of the tribunal or a witness, then you're going to need some kind of different plug-in technology to do that. The teleconferencing technology itself can't do much more other than share your screen at the moment. So there is that to bear in mind. I think it's also probably worth saying a word or two about cybersecurity concerns. And I'm going to say this as someone who was on the ICA, IBA, not IBA, ICA, New York arbitration, sorry, it's too early in the morning. Anyway, ICA and two other entities, committee on cybersecurity. Cybersecurity issues in video are frankly not likely to happen. Yes, you can, if the Russian intelligence directorate or GCHQ or the NSA or the 8200 unit of the Israeli Defense Force wants to hack into your video, they're going to hack into your video, okay? That's going to be probably a fairly rare example. On the other side of the spectrum, the vast majority of cybersecurity breaches are actually sort of low-tech problems, like you're leaving a password in the wrong place, or maybe responding to a phishing email or something like that, or having a very simple password that's easy to hack. In terms of the video conferencing itself, these are usually transit encrypted, not end-to-end encrypted. And in plain English, what that means is that if you're using, for instance, MS Teams right now, it is encrypted from where I'm using it to my server, but it is not encrypted from there to all of you. So in theory, if you have a backdoor into your server, you can hack into the video. But all the concerns about Zoom, for example, and its hackability, it was somewhat misplaced. What really happened with the phenomenon that we now know as Zoom bombing was really that Zoom is configurable so that you don't provide a password. And it was in the old days, that's to say about 2 or 3 weeks ago, it was in the old days the case that if you provided a Zoom link without a password, anyone could jump onto it. So that's what happened with Zoom bombing. You can, in fact, provide a password. And in fact, even if you don't provide a password nowadays, when you use Zoom, there is an automatic waiting room function, as I believe there is in MS Teams and WebEx, where you, as the originator of the call, have to let people in. So, we need not worry about some of these concerns that I think are somewhat overblown. Now, in terms of the protocols and procedures that are used in video conferencing, as some of you have adverted to before, we are seeing these develop very rapidly. The SOL protocol on video conferencing actually dates from a couple of years ago. There is Chartered Institute has come up with one just yesterday or the day before. The African Arbitration Academy has come up with a protocol on video conferencing. You will not go wanting for protocols on video conferencing and even sort of draft procedural orders on this sort of thing. This is becoming very much, if not de rigueur, at least very common. I think in terms of witnesses and all these concerns, again, I agree 100% with what Mike and Wendy and Maxi have said. The whole idea of witnesses is bound up, and witness testimony is bound up with our common law prejudices. And I say this obviously as an Anglo-American trained common lawyer who I probably wouldn't have been a lawyer if I were in the civil law context, because the cut and thrust of cross-examination is what I love. That said, it's not all about my preferences, it's about what's best for the process. So I think we have to acknowledge that the whole idea of witness testimony being critical to arbitration is vastly overblown. That said, again, if you really do want to do it, you can do it on these platforms. As Wendy said, make the screen bigger. If you're really concerned, really concerned that you can't quite get the sort of life-size, real-time experience on one of these platforms, then the gold standard, if you can get it in these days, is something called Cisco Telepresence, which is something that Mike has been talking about for many years. And Mike and I actually demoed in a mock arbitration all of 5 years ago. So telepresence is just like video conferencing on steroids, where it's high def, 4K, looks like the person literally is on the other end of the room. You can have absolutely no concerns whatsoever about time lag or not being able to see the reactions of witness or arbitrator contemporaneously with that kind of technology. And finally, let's bear in mind that this technology, this mature video conferencing technology, is going to be superseded fairly soon. And by fairly soon, I mean in the next 5 years, by stuff that's even better. It's only a matter of time before, rather than sort of staring at our telephones, we'll be staring through our glasses at augmented reality images, which are going to show pictures of all of us in fairly high definition. And that technology exists today. It's just not widely distributed. Same thing with virtual reality headsets. We may feel uncomfortable putting some kind of big thing over our heads, but that is going to provide us with a very real impression of being in a room with a tribunal, with witnesses, and with counsel. So even where we stand, I think we have more than we need, but let's not forget that coming down the pike is stuff that's going to be even more a replica of the old way of doing things. I've probably said enough in my morning burble, so I leave it to you, Patricia.
Well, Paul, you did a great job of bringing us right exactly on time, because this is when we were going to open up for discussion with the questions, and I can pitch that, but I also invite Maxi and Wendy and Mike and you, Paul, to jump in on some of the questions. Let me note that Benjamin Hughes is agreeing with you, Paul, and he also notes that the security settings can be improved on Zoom, and in fact, it's been reported in the news that the English government is using Zoom, and the other platforms, I guess, are all upping the game on security. But who do you think should be responsible for ensuring the security? Should it be the arbitrators? Should it be the parties? Or should, if it's a sufficiently large case, that one engages one of the services that are now being offered through different hearing centers to arrange all the technology?
I think much as the integrity of the proceeding is sort of the responsibility of all the stakeholders to some degree or other, I think we have to treat the security in a similar way. It's incumbent on all of us to consider the ways in which we can protect the proceeding. I'm loath to right now to assign a responsibility to any one particular entity or stakeholder, simply because I think we all need to be on the hook for that. and I'm not sure right now, especially in this nascent era, that we can attribute it to the arbitral tribunal, to the institution, or anyone else. Obviously, they bear a responsibility. I'm not sure they bear the responsibility.
Are there some questions or comments which our panelists would like to address?
I'm happy to just jump in here and say I totally agree with what Paul just said about the various platforms. I'm always a bit hesitant to advertising a certain brand because I don't think that's my role as arbitrator or professor. But and I think there are two important distinctions that we should keep in mind. First of all, any of those platforms has different levels of licenses. So whatever brand we've just mentioned has actually different levels of licenses and comes with different levels of securities. So it's a bit like, comparing apples and pears. The other thing I think an important distinction to make is the sort of Zoom bombing or cybersecurity concern that Paul mentioned. And I agree with him that is probably overblown, specifically if you consider that, some arbitrators still use Gmail. And then on the other hand, however, there is, I think, an important question, and that is who's actually owning the data that is used on the platform. And that's nothing to do with, some, third-party hacking your video conference, but is the data that is produced during the hearing owned by the platform that you're using, and what are their rights? Regarding that data. This has data privacy concerns, but obviously if the arbitration is confidential, has also some concerns. I'm not saying that these are, issues that cannot be resolved, but I think there are issues that we should be mindful of and looking into the terms of conditions of the specific platform we're using at the specific level of licensing that we are using.
Hey, by the way, if I can answer.
Let me just go ahead, but I just want to grab one question on Maxi's point that was early on, that someone asked about at the enforcement or set-aside proceedings, things which are on the platform, can they be transferred into the court action?
I think you need to be, sorry, shall I answer that before Mike comes on with this? I think you need to be a bit careful to distinguish between a virtual hearing and an online document platform, because they're two different beasts. And the SCC offers an online document platform, and as Lee's clarified on the chat, it's integrated for the purpose of this panel, but it's not actually integrated as yet for the purpose of hearings. But you can have that SCC online platform with your documents on one screen and run any video conferencing platform through your other screen. So what certainly is recommended by our IT specialists on Zoom is turn off the recording. Don't set the recording. And then there may be technology experts who will contradict me on this. But if the recording is off, there shouldn't be collection of data on that virtual hearing platform. So if PowerPoints, demonstratives are put up in the course of opening and closing statements, if documents are put to witnesses, they shouldn't be recorded on that virtual hearing platform. They are contained on the online electronic bundle or electronic document platform, but you've signed a contract with all of your issues on data protection on that anyway, and we've been doing that for decades. As to which platform, I too am not recommending any one or the other, but there is no one size fits all. And the beauty of some of the very, very simple, easy to use, easily accessible ones like Skype for Business, like Zoom licensed, is provided one person's license and that person hosts, you can put on maximum security, but it's just incredibly easy to use. Whereas if you take something like the IDRC Hearing Centre in London, offers an integrated platform with Opus 2, which is absolutely brilliant, but you will pay for it. So there is no one size fits all, but there is a size for anyone and anything.
Yeah,
Mike.
Patricia, I was going to just jump in. There was a comment from one of the professor arbitrator who said that, I think it's a he, if I get the gender right, but that participated in a hearing from New York using Cisco telepresence, and it was like being in the same room. I had a similar experience recently where we were preparing for a hearing in New York, and one of our key witnesses, somebody who we thought would actually be a really good witness on important issues, really credible guy who was there on the construction site, had real familiarity, we thought he would come across well, had a visa problem, couldn't get into the United States. And so we had a hearing the second week of December where he was coming in. The week before, this is the week before when he realized he wasn't going to make it in. I'll read you the email from my outside counsel. I said, see if you can get a Cisco telepresence, because we can have him fly to London, where we have telepresence in our offices, and we have law firms that have it in their offices. And she wrote me back and said, Mike, I looked up rental services. It's $750 per day plus $750 for technical assistance, which is optional. It says if we don't purchase the technical assistance, the equipment will be delivered via FedEx, and we're responsible for the setup. So it was that easy. And by the way, the tribunal, I think they all uniformly said they thought it was amazing, that it was just like being there. Again, I think Paul's right. It's the high end of the sort of the gold standard, but it can be done. And I think that what we've seen, those of us who've been using Cisco over the last many years, dozen or so years, is it keeps getting more and more portable and easy to use. Kind of like Iron Man's suits, like it keeps being collapsible, until it's like smaller and smaller containers, and
There's a question that came up about ensuring the confidentiality with the recording functions and all of this. Is that something which should be put into the procedural orders? I guess it should be agreed, and Wendy has been urging that there needs to be dialogue to talk these things through.
I read that question, and my initial answer, the question for those who haven't seen it is, it's very easy to turn on your recording function. It's also very easy to put your iPhone next to the phone and record the session, but you can do that in a hearing. If you really want to do that, you can do it in a hearing. There is some degree of trust in these proceedings. The confidentiality or the privacy of the proceedings proceeds on the basis of trust. So I think we do have to behave a little bit grown up about those sorts of things, but absolutely talk about it. It's important. GDPR is important. Cybersecurity, confidentiality, all those things are important and can and should be incorporated in a procedural order number one in this day and age, because as I say, this is part of our new normal. Whether we want it to be or not, whether we like it or not, it is. So we best provide for it. And that is a good thing to provide for. But I don't think it's a massively bigger risk than one that exists already.
Well, I think what Mike has been urging us is that we should not just see this as a new normal because of the current situation, but we should see how can we use this as a transformative opportunity to accomplish the things which all four of you have been talking about. How do we do a better job at what we do? This is an opportunity to shake out of our conservatism and to try to find new solutions. Now I sound like the governor of New York, Cuomo, about not rebuilding, but anyway, we have now remaining 5 minutes. So let me invite each of you. I'll go in maybe reverse order to see if you'd like to say something in the closing minute of what you think is how do we build better now? We'll start with you, Paul.
Again, I think it's too early in the morning for me to say anything mildly remotely intelligent, pardon pun. So let me just close by noting a couple of pieces of etiquette. You should probably mute your microphones in these meetings because there's lots of feedback and stuff like that. I think that's going to become part of the etiquette. The other thing is you should probably wear trousers when you are actually in a video, as a reporter in an American news show found to his detriment. He was dressed in a nice jacket and shirt, but unfortunately didn't realize that the video showed that he was wearing no trousers. So wear trousers. That's my advice.
Maxi? Sorry, I'm going the wrong order. I'm sorry, it's Mike that's next. I was going reverse. Sorry.
I would say, I will just say, go out, maybe what's out of scope of this group, which is that I hope that we embrace, we don't let the a pandemic and all the terrible sacrifices and things that happen, that we don't let all of this initiative towards change go to waste. And afterwards we, go back to doing things as we did before. I've enjoyed working from home. I'm not at home today. I'm at the office for the first time in a while. But I think a lot of us have seen some real improvements in society. And I hope that arbitration will change like that as well. I think that what I really hope is that the process of dispute resolution will evolve. And as we face into the crisis of defaulting contracts, of backlogs in the courts, of ways to augment, and I hope that people who are dialing in will all be part of not just promoting change, but I hope that as mediators and arbitrators, I've seen both listed here who've dialed in, who are listening. I hope that you will have work to take this burden away from the courts. And in doing that, you look for not just the processes that we had before, but something that we haven't even thought of yet, some way of resolving disputes that gets to Wendy's point of delivering justice and leaving parties satisfied. Again, may not be perfect, but that, gives people what they need within a reasonable time.
Okay, Wendy, I'm going to turn to you for your prediction.
Let me finish where I started, communication. If anything, let this be a catalyst for improving communication. I do take on board the question that was posted and raised about physical hearings. Without them, we lose the opportunity for the conversation at the coffee machine. But the only reason that's important is because all other communication has broken down. And so certainly through these types of meetings, why not have the procedural hearings by Zoom? Part of the reason, or by virtual platform, part of the reason we didn't do them in person was because of the expense. And so it became the default to do them by phone or not at all. And what we need in order to enhance the resolution of disputes is more communication. And part of that has to be a constant renewal, refresh, and revision by the tribunal and by the parties throughout the proceedings as to whether or not that setting of what was going to happen over the next 18 months to 2 years on day one and procedural order number one is still fit for purpose. Because certainly those PO1s that were put out last year are not fit for purpose for today. But it shouldn't take COVID to make us review those. We should be reviewing them all the way through proceedings because things change, things move, and it shouldn't be on the last day at the coffee break that we actually acknowledge that and have that conversation. Let's get there quicker. Let's communicate the whole way.
Great message. Maxi, you have the privilege of both starting and ending our seminar.
Oh dear. So I'll be quick. Thanks to the SCC for putting this up. Thanks to the co-panelists. Thanks to all the wonderful questions. I have two thoughts. One is, do not just transplant what we usually do in an online hearing. Let's think about new things. And my main focus on thinking to get things done is front load, and front load. Think about things early, read things early, get things resolved early, meet early in person if needed. And my last innovative thought is don't wear trousers, wear skirts. Patricia, I think you're on mute.
Can you hear me now? Good. It's been a great privilege to be able to enjoy this afternoon and to learn from all of your experience and insights. And I think you're leaving us with a very hopeful note in this time, which maybe has been a bit, in some ways, depressing for people, that we can turn this into the silver lining and having something positive. And maybe with this dialogue and planning and front-end loading, that will also help us to deal with the issues that some have about what will happen at the point of setting aside an enforcement. That if everything is well documented, well planned, there's been good dialogue, there's been good solutions, there's been taking into consideration all of the different features, that maybe you'll end up with a enforceable award that also was more effective and more efficient. And to make Mike happy, the parties actually found the outcome was worth the process. So thank you very much to SCC, to Lise, to Annette, and to all of our participants who have spent their afternoon with us. Hope to see
And-
all of you in real life soon.
And thank you to Patricia and all the panelists, and also a big thank you to an amazing audience, I must say. You have been so active on the chat function, which is really, really inspiring. Not only have you posted questions, but you have also talked to each other, and you have shared information about cases, about practice, and really, really made this interactive. And I hope 1 + 1 has equaled 3 for the last 90 minutes or so. So thank you to everyone, and I think we will continue this conversation going forward, and see you next time then. And also, I should say a big thank you to Lise and Fabian, who's really been behind the scene from the beginning to end. Thank you, Lise and Fabian, and see you later, everyone.